Is a tomato a fruit? That's what the Supreme Court case Nix v. Hedden determined. Here's John Nix, who founded a fruit commission in New York City in 1839 and became one of the largest sellers of produce during the time. Now let's jump ahead 44 years to 1883, where President Arthur signed the Tariff Act of 1883, and the important part of this tariff is that taxes had to be paid on imported vegetables, not fruit. Now, the Fruit Commission that Nix founded imported tomatoes from the West Indies and paid these duties under protest, so they obviously wanted the money back, so they filed a lawsuit against the collector of the Port of New York, Edward Hedden, and this was done in February of 1887. Nix's argument was that a tomato was a fruit, so he didn't have to pay this tariff on the imported good. Seems pretty logical. Looking at a biological perspective, they stated tomatoes were fruits because they contained a seed-bearing structure that grows from the flowering part of the plant. At the trial, they called in two witnesses who had been in the produce sales business for over 30 years, and they read to them the definitions of fruits and vegetables from three dictionaries: the Webster's Dictionary, the Worcester's Dictionary, and the Imperial Dictionary. The dictionaries referred to fruit as the seed of plants, or that part of plants which contains the seed, and especially the juicy, pulpy products of certain plants covering and containing the seed. After reading these definitions, they then asked the witnesses to explain if these words had any special meaning in trade or commerce that were different from those read. One of the witnesses stated, "Well, it does not classify all things here, but they are correct as far as they go. It does not take all kinds of fruits or vegetables, it takes a portion of them. I think the words fruit and vegetable have the same meaning in trade today that they had on March 1st, 1883. I understand that the term fruit is applied in trade only to such plants or parts of plants as contain the seeds. There are more vegetables than those in the enumeration given in Webster's Dictionary under the term vegetable as cabbage, cauliflower, turnips, potatoes, peas, beans, and the like, probably covered by the words and the like." So that may have been gibberish to you, but essentially what this witness stated that even though the dictionary stated that vegetables differ biologically from fruits, as fruits refer to plants or parts of plants that contain seeds, the dictionary fails to list every single type of vegetable that's grown or imported into the country, which makes sense. And they use the term "and the like" in place of listing all of these vegetables, and implies that tomatoes could possibly fall into this classification. Essentially, there's no special meaning between the two terms in commerce. And this is what the other witness testified. It's a little shorter. "I don't think the term fruit or the term vegetables had, in March 1883, any prior thereto any special meaning in trade and commerce in this country, different from that which I have read here from the dictionaries." And what this means is that the witness testified that neither vegetables nor fruit had any special meaning in trade or commerce that differed from the given definitions in the dictionaries. They had the same meaning in trade that they had in March 1883 and that day in court. After the witnesses gave their accounts, the plaintiff's counsel read from the same dictionaries the definition of tomato. Then, the defendant's counsel then read from the dictionaries the definitions of pea, eggplant, cucumber, squash, and pepper. After that, the plaintiff's counsel then read the definitions from the same dictionaries for the following terms: potato, turnip, parsnip, cauliflower, cabbage, carrot, and bean. Their hopes were to find distinctions between the definitions of tomato and these other grown commodities that were not considered fruits, most of them being vegetables. This is the only evidence that's presented to the court, and a verdict was reached. Drum roll, please. A unanimous decision was made, and they concluded that a tomato is a fruit and a vegetable. The court ruled that tomatoes were biologically fruits because of their seed-bearing structure. However, in common speech, there was little evidence to support the fact that tomatoes were fruits and differed from vegetables. This common speech is the same speech with the same meanings of the terms used in the Tariff Act of 1883. And essentially, common speech is the speech used in the legislation. The dictionaries that both parties read from failed to show that tomatoes were only classified as fruits in common speech. The court did acknowledge that a tomato is a fruit of vine, which is common speech, but it also is very similar to cucumber, squashes, beans, and peas, which are not fruits, to say the least, and grow on vines. The court stated that in the common language of the people, whether sellers or consumers of provisions, all of these are vegetables, which are grown in kitchen gardens. In summary, tomatoes aren't that special and don't have any clear commonplace differences from other vegetables and other goods that are taxed under this tariff. They stated that classifying a tomato as a fruit is like saying a bean is a seed. Justice Bradley stated, "We do not see why they should be classified as seeds any more than walnuts should be so classified. Both are seeds in the language of botany or natural history, but not in commerce nor in common parlance. On the other hand, in speaking generally of provisions, beans may well be included under the term vegetables. As an article of food on our tables, whether baked or boiled, or forming the basis of soup, They are used as a vegetable, as well as when ripe as when green. This is the principal use to which they are put. Beyond the common knowledge that we have on this subject, very little evidence is necessary or it can be produced. All in all, the government sees the tomato as a taxable vegetable and has a payable tariff when imported into the country. And that's the case. I'll link below the official case from the Library of Congress's website. Please like, subscribe, and comment down below. It's pretty cool stuff. And yeah, I hope you found this interesting. And go check out some other videos. I'll see you guys in the next one. Adios.